Court of Appeals in the matter of J, M, S, K, B and P children.
This is a bit like the curtain call at the end of production. An issue was raised overnight about the live stream being on when the court had adjourned for a short time. I understand that that's the norm. I didn't know that. But in any event, the YouTube record of yesterday's hearing has been taken down and is being edited so that only the sections that record the time when the court was sitting will be put back up. So thank you for raising that. And it's if it is the norm, then it's a word to the wise, isn't it? But, be careful. Right, well, where are we now?
My Lord, if I might rise first, just to come back on the outcome of our musings overnight of where the court had got to, or were the discussions over the proposed declarations. I make these submissions on behalf of the Secretary of State as a point of policy and interpretation of the provision, not on behalf of the Registrar General, who needs to implement whatever declaration the court makes. Yesterday the court was considering various iterations of a potential declaration that was being put forward. And the point that was being discussed is essentially the basic point in civil procedure that he who asserts must prove, which obviously as a basic proposition the Secretary of State unsurprisingly takes no issue with. The only point we do make is a particular one which arises in this context, in the context of Section 55A declarations. Because what Section 55A is concerned with is a declaration as to whether or not a person named in the application is the parent of the person so named. So the point that was being explored yesterday with my Lord Justice Stuart-Smith is, well, if person A asserts he is the father of the child, if he cannot establish to the requisite standard of proof that he is the father, therefore it must follow that he is not the father. We make no submissions on the facts, so if I can take it away from the facts, but if someone asserts something and they can't prove it, all that establishes is that they haven't proven the thing that they assert. It doesn't necessarily establish that the opposite is true. And if we just look at Section 58 at page 230 of the Authorities Bundle, what the court has to be satisfied of before making a declaration, so we see 58.1, where on an application to a court for a declaration, the truth of the proposition to be declared is proved to the satisfaction of the court. So if a court is considering making a declaration that a person is not the father of the child, the court also had, before they can make that declaration, the court must be satisfied of the truth of that proposition which is to be declared, which may be rather different to the normal sort of common law point. So again, we make no submissions on the facts, we just simply wanted to highlight that particular aspect of this jurisdiction.
What was driving my thinking yesterday was that it seems to me to be unsatisfactory to have an entry on the register which is correct, or may not be, when the child's interest in knowing the truth can be protected. But we have, with microphones off, had discussions outside. And I understand rather better now the implications of fashioning a declaration or a non-declaration in the way that I was suggesting yesterday. What the implications could be down the line.
My Lord, that's
You're
right.
right. You're right to draw the distinction between not proving and proving the negative. If one puts it the other way around, if the declaration being sought was by F2, F1 is not the father, then the court would not be satisfied to make that declaration.
My Lord, as I say, I don't want to make any submissions on the facts, but that would follow.
I've just used the letters for convenience.
Yes, that would follow from the interpretation that we would suggest. Yes.
Yeah.
My lord, that was all I wanted to say. So I will sit down
well,
and give
that's
way to.
helpful.
I'm not sure who else.
Thank you.
I'm sure someone will put that.
Yes, Miss Camp.
Very gracious, thank you, my lords, my lady. I act on behalf of the Association of Lawyers for Children with Miss Fotterill, Casey, who cannot be here today, and no disrespect is intended to the court, and Miss Bennett. If I may briefly wish to make 3 points.
Yes, well, we're very grateful to you and also to Reunite for all the work that's gone in by busy practitioners on a pro bono basis to assist the court. It's very valuable and welcome. Thank you.
And thank you, my lord. First, then, if I may, the first point I will wish to address you on is centrality of the child's identity to the statutory scheme as it was constructed. The second point would be the necessity of viewing the scheme as a whole and maintaining the integrity of the statutory scheme. And the third, the consequences where parental responsibility is acquired in error is, we say, clear under the scheme itself. And whilst you've heard extensive submissions from the Secretary of State, we will not be repeating those, but we may seek to amplify
The consequences of...
Forgive me. The consequences where parental responsibility is acquired in error is clear, we say, under the scheme itself, and I just wish to briefly address you on that point.
Thank you.
So if I may start with the child's right to identity. From the child's perspective, knowledge of their parentage and clarity about their legal relationships is fundamental. It ensures legal and psychological security, social identity, and an understanding of their personal history. The LC submits that the court's approach to parental responsibility should reflect that these are not abstract legal constructs, but integral components of a child's welfare and their self-concept. And we would make reference to those points in paragraph 7 of our skeleton argument. But it is, we submit, a really central matter for the court to have regard to. Right to identity is codified under international law and is recognised as a separate right under the United Nations Convention on the Rights of the Child, and is also part, of course, of the right for private life under the European Convention of Human Rights, Article 8. And we set out in our skeleton argument at paragraphs 14 to 16. I'm not going to repeat those, they're there for your reading, my lords and my lady. That's in the Common Legal Issues bundle at 383, going over the page 384. We just map the case law as to how what you find in Articles 7 and 8 really is reflected now in the case law in the European Court of Human Rights in Article 8 of the Human Rights Convention. So they really come to the same place. It's a right, of course, held not just by children but by adults, of course, in the light of the European Convention. And the fact that the UNCRC is not incorporated does not negate this court's obligation to have regard to and be bound by its provisions. It informed and underpinned the Children Act, and this court's made those observations before in case law. And indeed, the Children Act gives effect to its international obligations, the UK's international obligations under the UNCRC. Whenever, for example, the UK reports its progress against the obligations, the government makes and draws attention to the Children Act as an important document and statute that gives effect to those obligations. So in terms of those obligations, a right to know the truth of your legal and genetic parentage, identity, and the right to be cared for by your parents so far as possible are reflected and we respectfully submit ought to be promoted and respected in any interpretation of these provisions. Notably, of course, the European courts have repeatedly relied upon the provisions of the UNCRC when interpreting Article 8 and the parameters of family life. I only make this point, of course, because the Secretary of State raised yesterday a very important decision of our SC and the Secretary of State for Works and Pensions at 2022 AC 223, And indeed, there's a very helpful summary of the position that was arrived at on unincorporated international conventions at paragraph 3 of the head note. But more specifically, at looking at how it is to be used by courts in the UK, paragraphs 86 and 92. And I don't seek to take the court to those, but just to say that it's, of course, no part of the case of the Association of Lawyers to Children to say that it is in some way something that's enforceable. We put it no higher than I have in these oral submissions.
So it's informative rather than enforceable.
Yes, and of course it's something that we know was part, because of the statutory materials, we know was part and informed this construction of the Children Act, and as I say, is reported back as one of our flagship statutes that incorporates and gives effect to these rights. So it isn't a factor.
Of course, it is incorporated in Scottish law.
It is.
This court was the Scottish Court of Appeal, the equivalent. We'd have to take account of it.
And indeed, forgive me, but there's a call for evidence of the Human Rights Select Committee at this moment be considering whether or not the English law and Welsh law should incorporate. But that's a matter aside for now. I put it no higher than I have.
Am I right in understanding that your submission, which I think is uncontroversial, would be that although unincorporated, A, it's informative, and B, it's entirely consistent with what the English law is?
My lord, yes.
Or is that pushing it too far?
Not at all. And indeed, that's the submission we made, that the Association of Lawyers for Children, the Secretary of State, came to the same place. Whilst we came through a convention rights route, we nevertheless came to the same place on our interpretation of the statutory scheme. And Articles 7 and 8 of the UNCRC and Article 8 of the European Convention are all entirely consistent with the interpretation by the Secretary of State and by the Association of Lawyers for Children and some of the respondents to these appeals. So yes, my lord, and of course put more beautifully than I did in praising. I'm grateful. So with that in mind, may I move then to my second point?
Yes.
The necessity of viewing the scheme as a whole and maintaining the integrity of the scheme. Parliament enacted the scheme fixing the status of parental responsibility to parentage of the child we respectfully submit. This was the fulcrum around which the scheme was designed. We take you, of course, in particular in our skeleton argument, I'll refer back to it in a moment, to paragraph 2.3 of the Law Commission's paper, and its parenthood as a primary concept is very clearly set out. And indeed, we set out in our skeleton argument how at the stage at which they were reviewing the law, there were legal guardians who were still parents. There were legal guardians with the same rights as parents, and the Law Commission took the view that there needed to be clarity about the special status of parentage and the legal rights that flow from it. And guardianship would be dealt with separately under the scheme, and I'll briefly return to that in a moment. So the aims and the purpose of the statute in respect of parentage and parental responsibility we submit are evident across the scheme. The parliamentary intention can be illuminated, of course, as you have heard from the learned friend for the Secretary of State, by the Law Commission report number 172, the Family Law Review of Child Law and Guardianship and Custody. You've been taken through a number of those salient paragraphs, and I don't intend to repeat those, but I adopt those submissions, if I may, on behalf of the Association of Lawyers for Children. And may I just briefly highlight some additional paragraphs for your reading in due course in relation to your judgments that we may assist. So parenthood as a primary concept is referred to at paragraphs 2.3. That you will find in the authorities bundle at 3187. And that being the mother by birth, the father by biology, or legal status, and of course identifying that a legal status of parentage is a fundamentally special position we submit.
3187.
Yes, so 3187.
Law Chancellor's Department report.
Sorry, forgive me.
That's the Law Commission report.
Law Commission.
Yes, the Law Commission report. So paragraph 2.3, it deals with that point I made, that for all practical purposes, so the paragraph before sets out the way the scheme has operated, and of course says it's archaic and confusing, so very clearly going to change it, under which parents for all practical purposes have the same rights and authority as guardians and sometimes not, and that should be abolished. It goes on, of course, instead parenthood should become the primary concept, and this is at the very beginning of the paper. This is the framework we submit for what you see then mapped into the scheme, which was so carefully taken to by Ms Clement yesterday. Another paragraph, of course, that is quite useful is paragraph 2.4, because it follows on to incorporate from parentage then the status of parental responsibility, what it is and how it came to being, but it importantly makes the point parents have a prior claim to look after or have contact with their children as against their parties, and that's over the page. At the top of the page in the second sentence, at 3188. So again, that special status of parentage emphasised. Again, that's all entirely consistent with the interpretation been taken through with the Secretary of State. And then perhaps it may be of relevance to consider paragraph 2.9, again over the page, and this is just going through the scope of parental responsibility, and contemplates the point that was raised. I only raised this because on day one in argument there were questions raised about people who perhaps have care of a child but don't have parental responsibility, and that was raised by the court. And here that was contemplated. The fact that a parent does not have parental responsibility to care and upbringing a child does not affect the rights of the child in particular to be maintained or succeed to their estate. And this was also picked up, again, in paragraph 2.16, but I won't jump around, I'll just come to that in order because I don't wish you to be flicking back and two. But then, if I may also draw attention briefly to paragraph 2.11 at the bottom of that page, about parents not losing parental responsibility, but that's of course parents who have parental responsibility. And that's the course of point that was made by the court yesterday, so I won't trouble you further, just draw your attention to it. There is a footnote at number 36, which makes reference to a married father's acquisition when a care order is in force. So, of course, talking about people who are parents still being able to get that legal status, even if there are orders which curtail it. And then, if I may just briefly draw your attention to paragraph 2.16, because section 3.5, which my Lord Stuart-Smith, of course, questioned a couple of the barristers about on Monday, and it's significant. So it indeed arose from the section E on page 3191 at 2.16, the position of those without parental responsibility. And importantly, here, in the middle of that paragraph, we therefore recommend that it be made quite clear that anyone with actual care of a child may do what is reasonable in all the circumstances of the case for the purpose of safeguarding and promoting. An obvious example, medical treatment, child left with friends where parents go on holiday would obviously not be reasonable for major elective surgery, but would be reasonable to arrange whatever was advised in the event of an accident to the child, and then goes on just to look at what actual care is, and indeed contemplates within those few sentences actual custody without having parental responsibility. And that section 3.5 could extend to managing a child's life in that way. And so in our respectful submission, that those matters may be of some relevance when drawing the strands together of how the scheme sought to protect children and contemplate that they would have important psychological parents or others who would support their care, indeed give care fully, but nevertheless, and of course delegated parental responsibility. Guardians, of course, there were some questions raised about guardianship, and perhaps a very important paragraph at 3193, if I may turn you over to paragraph, forgive me, yes, 2.25. At the end of that paragraph, and this specific paragraph is looking at what if a guardian has parental responsibility. Is it the same parental responsibility a parent would have? Could they appoint a guardian, for example, in the event of their death? But importantly says, If appointing a guardian is an aspect of responsible parenthood, it can no less be an aspect of responsible guardianship. But goes on to say in the last sentence, the court will have ample powers to remove guardians or make whatever orders are necessary to safeguard and promote a child's welfare. So, of course, recognising that if somebody, and just taking it back to the submissions you heard on Monday, if somebody had appointed a guardian, believing they had PR, but indeed did not, the court's powers, the whole range of powers to discharge the guardian, to look at the child's welfare afresh and identify who's the right person to look after it, are there, and they were, of course, contemplated in the scheme, albeit in relation to the guardian appointing a guardian rather than a
Or
person.
confirm the putative guardian.
Precisely so, my lord. Yes, which may well be the best welfare interests of the child, but it would be a welfare determination, and the scheme has ample remedies available under the Children Act for the court to make the right nuanced decision for the child and put in place the right orders. So the law relating to parentage and parental responsibility we submit, as the Secretary of State did, was designed to ensure certainty as to who is entitled to make decisions about a child's upbringing. And the ALC submits that the court would need compelling justification to go behind such a clear objective by Parliament, to expand the categories of person who can have PR for a child beyond biological father and a mother who gave birth, and the limited exceptions of parenthood, which are very clearly set out in the scheme that you've heard about over the last 2 days. The ALC considers it be wrong for this court to read anything into the fact that Parliament did not require genetic testing for non-married fathers as a precondition to acquiring PR on the birth certificate, as some of the appellants have contended. So if I may then just move to my last point, which is the consequences of acquiring parental responsibility in error. The ALC submits that it follows from the scheme itself that there are clear legal consequences of acquiring parental responsibility. Appearing to acquire parental responsibility.
Your case is they don't acquire.
Of course.
Yeah.
So if it transpires, of course our case is that if it transpires you're not the father, then you never had it. And likewise, if it transpires you're not the mother, you never had it. And we make reference in our skeleton argument to the Nigerian fertility case by Deputy High Court Judge Tyler Casey, which is a really interesting set of facts. I mean, on the face of it, in UK law, that's a mother and father married with their own children, have a baby in their care, and indeed a case in which turns out that they had potentially baby farmed a child from Nigeria, and they were false documents. And what you have then is a position whereby the mother is indeed not the mother, and therefore never have parental responsibility on the conclusion of the learned judge, and the father's not the father and never have parental responsibility. We don't know who the mother is or who the father is, and they're the ones who would, under English law, potentially have that. So it appears to be common ground now that, of course, that father means genetic father, and only such person as, save the statutory exceptions, have PR for a child, whether it's acquired or it's automatic, and only a woman who's given birth to the child, save the statutory exceptions, would have PR. That is, we submit certainty. It sets the preconditions for having parental responsibility. If, as we submit this court, should clarify that if a person is on the birth certificate and they are not the biological father, they never have PR. And if you're married to a mother, you are not the biological father, then you never have PR. Then that would provide transparency and certainty within the law for people going forward. Individuals can arrange their affairs accordingly. Some people may gamble on the prospect that they're not the father, but nevertheless go on to make a parental responsibility agreement. Some people may not. They may ensure that they've clarified the position if they are having doubts. So it's suggested that there is uncertainty by the interpretation contended for by the Association and by the Secretary of State, and there is not. Indeed, it provides the clarity that is required, and it allows people to arrange their affairs accordingly, which, of course, is with advice, which is the essence, of course, of any statutory scheme. Nothing in the circumstances of or the consequences to those non-genetically related men changes a child's right to know their parentage and to have decision-making about their upbringing vested in their biological parents subject to the exceptions under the scheme. And if the scheme is interpreted as we and the Secretary of State and other respondents contend for, then the same consequences are true for a person who is not in fact the mother, who is not the non-genetically related husband of the mother, who is a non-married, non-genetically related man, who is on the birth certificate, or somebody with a PR agreement. They never have PR for the child. It's entirely consistent across the scheme. If the appellants are correct, then a person who is not in fact the mother, not the non-genetically related husband of the mother, they would retain PR until the child's majority, despite non-parentage, with no means of removing it. Some unmarried, non-genetically related men may keep PR, and some may not. But that creates uncertainty, it creates inconsistency in the distribution of parental responsibility. There is then no linkage to parentage, which was, of course, the primary concept that was contemplated when the scheme was designed.
One of the, forgive me for interrupting you, one of the judgments refers to the putative father's discovery that he's not the biological father in a rather different way to the way that most people have been talking about it. Most people have been talking about, in the submissions we've heard about it, losing parental responsibility. Whereas one of the judgments, I think it's in M possibly, says, but there's another side, which is a person who is not the genetic father, but has been labouring under the illusion that the child is theirs and would not wish to have had parental responsibility for a child who is not in fact theirs. Is that real?
Of course that's real, because I mean, I've certainly represented individuals who found out at the court door they're not the father of a child. It's a devastating moment. And people can at times need to come to a place where they have to make a decision as to what their role will be, and one of that may be I wish to walk away, or I wish to move on with my life in a different way. These are terribly distressing decisions, and the whole range of options are available to everybody, and indeed my Lord has identified there through that judgment one of the ways in which people might not want to retain PR. But the reality is this language of loss of PR, I made the mistake myself a little early in the submission, never had it. And so there is confused language across the scheme, which is why, of course, my Lord.
It's very helpful for me. For my Lord and my Lady, it may be not something that needed to be asked, but for me that's helpful.
It's a very difficult part as a family lawyer to deal with that, because they have to explain all of the different options, all the different range of things available, but it's crucially a devastating and emotionally devastating moment for people very often. So it is something we encounter, and precisely that decision is a perfectly reasonable one in those circumstances. So any call for flexibility in the scheme, which you heard from the appellant through Miss Briggs, King's Counsel, we respectfully submit as an adult-centred approach, not a child-centred approach. It's not for the benefit of children or consistent with their domestic or international rights under Articles 7 and 8, and then, of course, under the ECHR Article 8. Important persons or psychological parents have a very important role to play in a child's life, but can secure their involvement if an order is necessary through, of course, as you've identified in various submissions, Section 8 orders and Section 12. The court provides welfare dictated routes to the acquisition, the scheme provides welfare dictated routes to the acquisition of parental responsibility. The court is driven in circumstances before it to make a declaration under Section 55A that a person is not the parent of a child, then the ARC submits that it follows that the appearance of PR, erroneously or fraudulently acquired, is illusory. Told otherwise would dilute the identity rights of children. Unless I can assist you further, those are the submissions for the association.
Very helpful. Thank you very much.
Grateful.
Thank you.
Thank you.
Yes, Mr. Gratian.
Lords, my lady, Reunite is, of course, also very grateful to have been given permission to intervene in these appeals.
Yes.
We were, in fact, or Reunite was, in fact, given permission to intervene at a time when these appeals were only Re J. And the permission we were given was to make written submissions and to attend, and that's why we attend today, to answer any questions that the court might have had about the written submissions that had been lodged on Reunite's behalf. And so I don't want to trespass upon the court's time any more than is necessary by seeking to make extensive submissions. Subject to any questions, there is, if the court will indulge me, only one point that I wanted to address that has arisen
Before
during the
we
course.
get your submissions up on the screen, just a minute. And they're right at the end, aren't they? 336. Yeah. Yes. So you want to make one?
There's
Spoke
one area
submission, yeah.
that I wished to address, which really, and putting it frankly, is Reunite's main concern in the context of these proceedings, which is how children can be in circumstances where one of the outcomes of the appeal may be that fathers who understood they had parental responsibility turned out not to and never to have had it, protected from the fallout of that in the context of the impact on what has come to be termed in the submissions that have already been made as the abduction gap or the jurisdiction gap that inevitably and clearly arises in those circumstances. Taking this as swiftly as I possibly can, in both contexts, the key plank of enabling a parent to either seek return under the 1980 Hague Convention, or where it's engaged, or where to rely upon the retention of jurisdiction under the 1996 Hague Convention, Article 7, is whether that parent has rights of custody. We, in this country, interpret rights of custody as a right of veto, and it is generally understood that any parent that has parental responsibility will have a right of veto. They have a right to be involved in decisions about where their child should live, and particularly whether their child should be removed from England and Wales to, or the United Kingdom, to another country. As such, and this is why when the judgment in Re J was generally publicised, it hadn't been published yet, but the nature and effect of the decision was known. Reunite sought permission to intervene in the appeal because it seemed that this difficulty arose and hadn't been considered in the context of that judgment. That's not a criticism of the judge, it simply wasn't raised before her within those proceedings. Upon learning of it, Ms. Shalaby, the CEO of Reunite, undertook, as she does when considering any possible intervention, a broad survey of the workers on the Reunite advice line to see whether this was a real problem that Reunite encountered in the course of its work. And it was. They have an appreciable number of cases where there has been an international move and paternity of the child has then been challenged, with the consequence that rights of custody are thrown into question. A question was asked by my Lord Justice Stuart-Smith on the first morning of this appeal, which may seem a very long time ago now, as to what the impact would be on rights of custody if the parent, the father inevitably here, was caring for the child. As is sometimes the case with abduction 1980 Hague Convention proceedings, that is not a question that has a straightforward answer, but there are, or is, a concept that we have developed in English cases of inchoate rights of custody, where a parent or carer can be taken to have rights of custody in certain circumstances. But a father who is sharing the care of a child with a mother will not be taken to have inchoate rights of custody. Putting it as succinctly as possible, they will only have such rights if the mother has abandoned the care of the child to them and is not involved. There is, or has been prepared, a small pack of cases that deal with that, if you would be interested to see it. We've not handed it up so far because it seems as though the court is already more than well armed with authorities. But those cases provide an answer to that question. The short answer is that a father who was understanding they had parental responsibility, but it turns out wrongly understanding that, sharing the care of a child with a mother will not have rights of custody simply on that basis. So they would find themselves in the midst of the abduction or jurisdiction gap, as it has been termed. And that does give rise to a problem, because in cases of the international movement of children, particularly abduction, this is the protection that parents have. And of course, it's well known that some parents will fall outside of that scheme. The Hague Conventions of 1980 and 1996 work on the basis of relatively bright lines into which some parents will fall and some parents will not. But Reunite's perspective is looking at it from with a focus on the child. If the child has a parent who has been involved in their lives, understanding that they have parental responsibility, exercising that responsibly and fully, but it then transpires that they do not have that, and that child is then removed internationally by the mother, the consequences for that child will be the same. It doesn't, of course, every case is different, but from the child's perspective, the fact that the father turns out not to have had parental responsibility and not to have rights of custody is likely neither here nor there. The removal of the child from their settled circumstances and everything they know.
But the legal consequences are very different.
Yes.
Yes, but you're saying that it's just as shocking, if it is shocking for the child to be moved from a man who doesn't have parental responsibility, who's been a de facto father, as it is from someone who did have parental responsibility.
Exactly so.
I get that, yes.
And the harms of that are well known. There is, as my lords and my lady will appreciate, a lot of research about the consequences for children of being abducted and removed in that way, including from the parent that is left behind. And so, focusing on that, we, on behalf of Reunite, and the Secretary of State has made submissions in a similar way, but with a slightly different focus, have suggested that in the event that this court were to find that a person named on the birth certificate who turns out not to be the child's father never had parental responsibility, with the consequence that they couldn't then rely on those conventions to remedy a removal in one way or another, whether that is by a return application or relying on the retention of jurisdiction. It would be helpful and of assistance both to professionals practicing in this area but also parents if this court were to recognise that within a judgment and give some suggestions as to what could be done to ameliorate harm in situations.
So I thought your position, Reunite's position, was to support the appellants in M and J, and I'm looking at paragraph 7.1 of your skeleton, and submit that the definition of father doesn't have to be a genetic parent in order to acquire parental responsibility.
Yes, that is our primary position.
That's your primary. So I think
hadn't addressed that.
I think you're the only voice now arguing for that.
Well,
so I think we need to hear you on.
We aligned ourselves in that regard with the appeals as they were advanced in 3J and RIA.
Yes.
Insofar as that has...
Be corrected if I'm wrong, I think it's now accepted by the appellants in both those cases that the definition of father as a matter of law is confined to the biological, the genetic father.
Yes. Well, we, and I hope not to be seen to be ducking your question, but we move with their cases. We don't wish, on Reunite's behalf, to advance as the sole voice a position that isn't being advanced by any other party to the appeal. That doesn't seem to be Reunite's general role in any event, or the proper purpose of our intervention here. So insofar as the scope has shifted, my lord, we don't seek to advance independently a different position to the other parties.
Thank you.
And my lord,
so where we are, which is entirely proper position for Reunite to be in, is to point to the obvious adverse consequences for the child if there's a removal in the circumstances we've been describing of a man who thinks he's the father and has the legal
Indeed. And I
position
hope
of parental responsibility, but doesn't actually have that. So you're inviting the court to give guidance as to what to do there.
Yes.
Have you? I haven't gone back to your skeleton to see. Do you offer guidance, suggested guidance?
Yes, and that's what I was coming on to.
Good. So where in the skeleton?
Lord, before I just get to that, I had adopted or taken the approach that I had because I rather thought the court might have felt it's heard enough about the main legal issues.
Never.
So I was skipping directly, and I should have been clearer about this because it would have signposted more obviously where I was going. But I was skipping directly to what reunites see the issue as being in the event that the appeal falls a particular way.
Good.
My lord, we, within our skeleton argument at paragraph 29, address what we say the court could usefully do to assist, this court could usefully do to assist in that context.
Yeah.
As we understand the submissions made on behalf of the Secretary of State for Justice, they are also, and I think this was said yesterday, seeking guidance in relation to this. The focus of the guidance that was proposed on the Secretary of State's behalf was on what fathers could do, or people who thought they were fathers could do. And it was suggested that a prohibited steps order could be sought upon learning of this issue, or if learning after a removal, what we used to term a chasing order could be sought. So the focus of that guidance was what parents or people who thought they were parents could do. We suggest at paragraph 29b
Yes.
an approach with a slightly different focus, which is what a court should consider at a point where this issue is raised before it, whether that's in the context of a declaration of parentage or in the course of private law proceedings, or a combination of those two things, as some of these cases have been.
So in essence, you're saying that at the time the court is seized of an application for a declaration of non-parentage, as it would
Yes, as it would
be, there's a potential for the court beginning that hearing or leading up to that hearing, not making any substantive orders for the future, but you suggest that there should be a holding order made that affords parental responsibility to the person who thought they had it,
Well,
while the court then decides ultimately what the final outcome will be. Have I read paragraph 30?
we put
correctly?
it slightly differently, because
Right.
what we don't want, bearing in mind all of the issues that have arisen where it's taken that there are presumptions about particular outcomes, is to suggest that there should be a presumption that any particular order should be made. Every case will be different, and what the child in the particular case needs will vary case by case. So what we are actually saying is that the court should consider at that point what orders need to be put in place to maintain, we've called it scaffolding, but a framework around the child that allows the people that have been involved in making decisions about them to continue to do so.
Just on 29b, that's premised on the basis of what had before today been your position, namely that parental responsibility continued, notwithstanding that the father had been proved not to be the father by virtue of DNA. I presume that your B applies even if there had been no parental responsibility, because
That was the intention of that paragraph in any event. It was.
but it says which is presumed would be the point where in circumstances such as these parental responsibility would be lost. So I
Yes,
perhaps
I
misread that, but I
yes.
took that to
No,
mean
my
that
lady
was
is
part
right.
of your
That's the
overall.
way I read it.
Indeed, it applies whatever the approach is in that regard.
I understand. Thank you.
Really what we are trying to say is that upon it becoming apparent that there is this issue, the court has an opportunity there to step in and make orders if they are in the best interest of the particular child, which
Yeah.
of course is the key
Yes.
consideration.
I mean, I thought that's what I was suggesting to you. So, should the court, an application is made by the mother, it would probably be, for a declaration of non-parentage, at a very early stage when the court receives the application. Should it be placed before a judge, or should there be an early hearing to consider what holding order, what scaffolding or framework is put in place for the duration of the proceedings
Yes,
until a final determination is made.
indeed.
Hmm.
Because on this analysis,
But
upon that issue,
interim orders, if that's the right phrase.
yes,
Yeah.
and that would plug to a degree the gap, if that's the proper term, that has been identified as arising here. And the benefit of that being directed towards the court and what the court should do is that it then provides perhaps a better possibility for that being done in relation to parents who may be litigants in person.
Each case will be different, but an approach would be the issue comes to court before DNA testing is ordered, but she's saying, well, he's not the father, I know he's not. To avoid there being a gap when the DNA test drops into the email box, the court might make orders, if it's justified on the welfare of the child, making a lives with order or contact order and attaching a section 12 parental responsibility order
Yes.
to that for the time being. So
Oh,
that if in
precisely
the
so.
event of a removal of the child to another country, the moment the DNA lands, the court will have made orders and the convention will bite.
Yes, precisely.
Is it your contemplation that there will possibly with time develop a sort of standard set of provisions, or because as my lord has said, each case will be different. So there may be some cases where the need for protecting either the father or the child is acute, and some where it's less acute. So are you contemplating standardised or bespoke?
I think it's likely to be difficult for there to
You
be
wouldn't do
standardised
standardised, no.
directions.
Because
Because that then builds in a sort of presumption as to what the outcome might be. In circumstances where families being what they are, the particular circumstances will be almost endlessly variable. The main thing that we seek is identification that this is an issue that requires consideration at the earliest possible stage. What orders the judge then makes will depend upon the particular circumstances of the family and, crucially, what is in the welfare best interests of the particular child.
So it's what's being I just don't quite understand exactly how this would work, but is what's being contemplated that when an application for declaration of non-parentage comes into view, as a matter of routine, the court should look at the case with a view to identifying whether there are interim orders that need to be made.
Yes.
So the template would be that rather than the substance of what the orders, if they're made, would be.
And what we say is likely to assist in that is if this court, within its judgment, identify the issue and make plain that that should be done. Because the difficulty that can sometimes happen where issues like this arise is that the particular issue is dealt with, the consequences of that issue being resolved, in this case in one particular way, are foreseeable, but they're left then to be dealt with in another case later. And that gives rise to a position where parents who are aware of the gap can seek to exploit it, but others, individual judges who deal with cases, lawyers who advise people, or parents acting of themselves, may not know what can be done to resolve it.
So this might not be the language you'd use. You front-end load the sort of activity of the court in the hope of heading off much greater amounts of work if you don't have a protective scaffolding in place.
From the court's perspective, yes. From the child's perspective, to prevent situations where they're moved peremptorily or other unilateral decisions are taken in relation to them whilst this lacuna, if that's the proper term, exists. And there are different examples. In surrogacy cases, that is routinely done whilst a parental order is being considered by the court to ensure that there's a decision-making framework around the child while that happens. There are other examples. But identifying the issue is the first stage, we suggest, in protecting children from the fallout, which has been identified by Reunite, by the Secretary of State, with different calls for guidance put forward as to how this problem can be addressed.
Thank you.
Unless, my lords, my lady, there were any other questions that you
So
had.
so in terms of the guidance, is that it? That the court should have an early directions hearing and consider what orders should be made, or is there further guidance that Reunite would?
Well, the suggestion that was made on behalf of the Secretary of State is also valuable, because the provision of information generally to people
Yes.
assists. So our perspective from what the court can do is one side of it, but setting out what people who find themselves in this situation they themselves can do also has value, because it assists people who are advising them to.
One thing I think that certainly got whose submissions it fell into yesterday, but it was suggested that's the wrong thing, suggested that we should ages ago we should give guidance both as to what to do if the child is still in the jurisdiction, but also indicate what steps might be taken to the hapless individual
Yes.
who finds out they're a father after the family has flown.
Precisely so.
So-
And we would agree with that, because these are the situations that
Yes.
Reunite.
Well,
deals
are there
with
any?
most
I think it's be difficult for us to give granular guidance saying you must do this, you must do that. But the shape of that, I think it was described that the court in this jurisdiction would have to consider whether it retained jurisdiction.
Yes.
If it did, it would make orders for the return of the child. Are there any other orders Reunite would suggest?
Well, a return order, a chasing order, as I termed it, is one option. But it depends, as ever, on the particular.
Well, we're clearly
circumstances.
not going to give an extempore judgment today. I would certainly welcome if you think there's more detail that could be given by this court in any guidance, any suggestions from Reunite,
So,
any other party, as well as to what that guidance should be.
yeah.
It's not infrequently this advocates get up in the Court of Appeal and say we welcome guidance, and then no one helps the court as to what the guidance might be. And
Of course, we are more than happy to.
well, I think you are in a particularly advantageous position as Reunite to help us with suggested detail.
Yes.
It wouldn't apply to every case; each case would be different. But just as a checklist, have you thought of this? Have you thought of that? Have you thought of another remedy?
Well, we certainly
I think that would be helpful.
can work with the other parties to provide
Yes.
that. Yes.
Yes, I'm not inviting 35 separate
I,
submissions,
not
but,
take it that my
but
law
maybe
was.
they could come. Maybe they could all come through.
yes,
That would be. I find that helpful.
of course.
Thank you. Good. Well, I'm grateful to you. No, thank you very much, Mr. Gratian. Thank you for those behind you. So, where are we now? Certainly, there are those who are appellants or who have respondents' notice who have a right of reply, and we're keen to hear from any and all. So that's you, Miss Briggs, you, Mr. Momtaz, you, Miss Markham, and you, Mr. Bagchi. I think I'm right in that. Were any other parties expecting to make additional submissions at this stage on any aspect of the primary case that hasn't been vented?
Not as far as I'm aware, my lord. No doubt somebody will tell me otherwise if
No,
I'm
well,
wrong.
now's the moment. Good. So over to you to respond. if you
My lord,
wish to.
yes. We'd agreed that Mr. Momtaz will start
enough,
with his
good.
reply.
Yeah.
Lord, my lady, may I just address one matter, and it really goes to what's just been discussed in terms of what practical steps might be taken
Yes.
going forward if my lords and the lady decide that the meaning of the word father in the Children Act is genetic father, and must follow from that that persons in the position of the father in Re M and Re J have never had parental responsibility. What one can do to ameliorate the consequences of that
Yes.
to similar people going forward. And Lord, we touch on that at paragraph 28 in our skeleton argument at 156. We don't provide suggestions, but may I very briefly try to deal with some of those now.
Sorry, what page was it?
It's 156,
Thank
and it's the question of we've had a very interesting discussion about what legal parenthood means in common law, etc. But if a person does not have an understanding of that, then cannot be expected to have that necessarily that understanding, despite this court making that decision and providing clarity. What steps, if any, should be taken to try to bring that information forward, particularly when one is looking at the acquisition of parental responsibility under Section 4. So we submit very broadly there are likely to be two categories of putative fathers, one being in the position of the appellant in Re M, who did know in advance that he was not the child's biological father, but perhaps for reasons that my Lord the President articulated yesterday, it's not a question of straightforward dishonesty, but through a wish of becoming the father and other avenues effectively.
Yes, but we've all encountered individuals like that.
So that's one scenario. The second scenario may be the Re J position, where we would submit the putative father did not know, and in one view could not have been expected to know that he was not the father, certainly at the time the child was born. And those may be considered to be slightly different factual situations. There may be others, I don't know, I'm not putting that forward in an exclusive list, but those broadly seem to us to be the two factual scenarios. And we might ought to consider what should happen in that situation going forward. Now, Lord, I dealt with this, I think it was yesterday, but if one looks, please, at the ways in which parental responsibility can be acquired under Section 4. So we know one is through acquisition of the birth certificate. I'm not going to address that. I don't know whether information should be, for example, given by the registrar to a father who is registering. That may be too much. I'm not saying that the registrar should be in a position really to provide that information. I can see that's
I think that's
problematic.
so. Every birth that's registered, the registrar says, "Well, hang on, you might not be the father."
That's why I don't. That's why I don't.
You know, I've come across these cases.
That's why. So I think there is a problem there in that respect that one can't necessarily expect an official to provide that information. However, if one looks at the other two categories, which is PR agreement and court order, if one so if a person has or is getting legal advice, one can perhaps expect the competent legal advice would be that this is what the law says. If one looks, for example, at PR agreement, and I'm sorry that it's not in the bundle before you, it's one of the documents that we'd culled because the volume was so large, but it's only a two-page document, and we can certainly forward it to my Lord and my Lords and my Lady if you wish to see it. But on the second page of the standard PR agreement, it says this under notes about parental responsibility, and I'll read that if I may. The making of this agreement will affect the legal position of the mother and the father. You should both seek legal advice before you make the agreement. Lord, this court may take the view that seeking legal advice is sufficient. It may be that some people won't take that legal advice, either because they decide to or they can't afford to.
Yeah, so the legal advice might not include. Well, it might not be the father. So what would you do if you're the person would be entering into the parental responsibility agreement on the basis, if they're category 1, they think they are the father. Would the advice be, well, anyway, I'd apply for a Section 8 when they're living together?
Yes. Well,
I was odd.
I'm so sorry. I was only going to suggest this, that one could add the following wording or something similar, that only a genetic father will acquire parental responsibility under this agreement. And at least that would bring it to their attention as an issue. Now, there may be a better way of phrasing it. I'm not suggesting that's the only way of doing it.
You should both seek legal advice.
Yes.
This may seem a ridiculous question to ask, in which case I apologise. Is there legal advice readily available for
there's a list
for normal people?
There's a list on the agreement which I've now got up.
Yes.
It says a local office of the family court, citizens' advice, law centre, or the library.
That slightly begs my question.
Yes, certainly, well, there are different forms, obviously, my lord, of legal advice. If the best way to do it would be to go to a family law solicitor, but that's likely to cost.
Another way, and obviously there are many ways, would be instead of having it there, some sort of banner on the form. This form should only be used
Yes.
in circumstances where the inverted commas father is the genetic father of the child.
Yes. So, my lord, it's providing the information, which is important
Yeah.
in my submission, so that can be acted upon.
Yeah.
In a situation where that person, although the legal position is going to become clear, may not know that that's the situation.
Yes, but that's helpful. Thank you.
Well, the second position perhaps is through court order, and I've addressed this to some extent yesterday. It may be too bold to say that in every case there should be a DNA test. I accept that. But one has to perhaps differentiate between a situation where a person is represented or where the court is presented with two litigants in person who say, we agree that the father should have PR. And one way of addressing that, I would submit, my lord, would be for the court to explain to those two litigants in person that it has to be the genetic father in order for a PR order to be made. I'm not suggesting that it's advice, but an explanation, and whether or not that explanation could be recorded on the face of the PR order.
So this is in under section 4(1)(c).
Yes, my lord.
Yeah. Yes, well, that's also helpful.
Well, may I just turn my back for a moment, just to see whether there's anything else? Oh, I've just got two emails.
Yeah.
Lords and ladies.
Your juniors, they're right over there, your juniors.
Yes, they are, but an issue has been correctly raised by my juniors, but I think I'll leave it there if I may.
Thank you.
Is there anything else I can assist with?
No, that's very helpful. Thank you very much. Yes, Miss Briggs.
My lords, my lady, I'm not going to rehearse the submissions made earlier. My submissions in response go really to in a similar vein to how we plug the gaps if we are with this legal interpretation. So the gaps appear to arise at the point before the declaration is made, so once there is doubt as to parentage, at the point of the declaration being made. And I'll make some suggestions without, I hope, micromanaging in respect of each of those points. And then I have a point to make about social and psychological parents, generally speaking.
Thank you.
And my lords, my ladies, sometimes, of course, as we've discovered, the legal outcome for parents is perhaps not what we would have chosen from a welfare perspective, and that is very much the position that my client finds himself in. Confronting the difficulties that might arise from that, we entirely endorse the proposal that this court considers and refers to steps that might be taken to protect the position, which of course, if one is a married man and finds that one is not the genetic parent, would extend to step-parent parental responsibility, which is a freestanding parental responsibility order. But as has been touched on, fathers may not realise until it is too late that they are not in fact the genetic parent, particularly where they're in a relationship that is being presented to them as a monogamous relationship. And in that regard, sometimes fathers may be in a disadvantage because for obvious reasons, the gestational parent will have a better idea as to whether or not they are the father or not of the child concerned. And that means that simply arranging one's affairs in accordance with this proposition that if one is not the genetic father, one does not have parental responsibility, might be quite a complex and sensitive thing, because to start probing that question may be difficult for many in the context of their relationship or indeed separation. Turning then to the position before a Section 55A declaration is made, so at the point at which the application has been made, as my lord said, by the mother, usually for the declaration of non-parentage or parentage. Of course, at this stage, the court is in the position that the court is in re-p, where the father may be the father and may not be the father.
Yeah.
And so the court is in a difficulty then in making parental responsibility orders on the basis that the father is not a father, because that determination has not been made. The specific difficulties that have been identified that would arise in almost every case where parental responsibility or assumed parental responsibility is revealed not to be parental responsibility are in the main of an international quality. So the abduction gap and the jurisdiction gap would be the legal scaffolding that could be put in place there to hold the ring would be a prohibited steps order not to remove the child from the jurisdiction. And that would instill in the court those rights of custody and would instill in the father, genetic or not, the necessary right of custody that would protect from the abduction gap and the jurisdiction gap from that point in time, without the court then having to determine, before the court can determine whether the father is father or not. And my lord,
Steps order would get over the rights of custody.
it would, because that would be the right of veto for the child not to be removed from the jurisdiction without the court's determination. Of course, that is the case if one gets to that point before the child has been removed, and we have to confront the point that there is always going to be a difficulty if that has not been established before the child has been removed. But in my submission, my lords and my lady, that particular point would benefit from there being some guidance from this court, because of course, frequently jurisdictional issues and abduction issues are not the bread and butter of the judiciary up and down the land. So that's a particularly important point we would suggest. Turning now, if I may, to the point where the declaration of parentage has been made, so the point at which my client found himself before Deborah Powell of His Majesty's Council, sitting as a High Court judge in December last year. Our client, of course, has been watching with interest the hearing, and he has found himself now in a position where the gap in time between the declaration being made and the welfare hearing is still going. So the next hearing in his case in the family court, which is still at an interim stage, is going to be in late January. And of course, he agreed to the declaration of parentage because that was the truth for Jay, and he was right to do so. And it comes back to our point that we make in writing, that the testing genetically can take days, moments, but the gathering of welfare evidence can take some time, and the finding of a hearing can take some time. And it's once we get outside of the point of declaration of parentage, once we know that the father is not the genetic father, that we say the court should examine parental responsibility under those other sections. So once one knows that he's not the father, Section 12 parental responsibility can be put in place, including under a spends time with order, and that's the point at which parental responsibility can attach to the parental quality of the role rather than to the genetic parentage.
Where I got to yesterday, in the short observation, was that in such a case, that it's possible to say, and I think during Miss Baisley's submissions,
Yes.
that if you can't say the person is the father, this is the early stage in the declaration procedure,
Yes.
that he is the father or is not the father, you can't put that individual into any one of the subsections of Section 12,
Yes.
and that's entirely right. But looking at Section 12 as a whole, the minimal position is that if the court makes this is Section 12, subsection 2, capital A.
Yes.
If the court makes a child arrangements order in relation to someone who's not a parent, and it's a spend time with order, the court may provide for that person to have parental responsibility. So there's a bottom line that even if you fail at all you fail to establish you're a father, you fail to get a lives with order, the court still, where in those cases the court must, or award parental responsibility. There's a bottom line position that the court has the discretion.
Yes.
And it seemed to me to be, without having discussed it with my lady or my lord, perfectly proper to say Section 12 as a whole gives the court at the very least a discretion to order parental responsibility. And if on the facts of a case at an early stage, before you can decide whether the person is or isn't a father, it's justified to exercise that, you could do that under the statute, saying, well, at the very least, this is a person who would be entitled to have spend time with order, and on the basis of the facts of the case, the child's welfare indicates that for the time being, I should award parental responsibility. So I don't know whether that's something that finds favour either on that side of the court or on the left or right of where I sit, but that's it's perhaps helpful to share it.
Yes, well, my lord, simply put, on my client's behalf, anything that would establish the status quo as he and the child saw it before the point of that declaration, he says would be protective of the child as well as
Because
him.
going back to Mr. Grayson's case, there is a gap,
Yes.
and the negative aspect of all this is that gap and the potential, in few cases presumably, but the potential for there to be a removal.
My lord, yes, and we would say that given the proof positive that would seem to need to be present for the various subsections of Section 12, we would remain of the position that a prohibited steps order should be made at that point. But the key
Yes, because that's the other. So yes, that's the
Yes.
other part of it. And I think I'm right that even if no substantive Section 8 orders are made, if the father, alongside the declaration proceedings, applies for a Section 8 order, then the court has custody, even if he doesn't. So I can see some nodding, and I can see your head shaking. But if there are pending welfare proceedings before the court, then the court has a right of custody, which so again, yeah, there's nodding.
Yes.
There's sufficient nodding for me to feel that's
But my lord, it really is that question of holding the ring and making sure that fathers are not in the position that my client has been in for the last year, which is absent parental responsibility. And that may be an order, we say, that could be made at an interim, at an early stage, to hold the ring, taking into account, of course, as the court would need to, the welfare checklist, but with specific focus on the status quo that has persisted before. The fact that the father in that position had, the natural father in that position was being consulted and was having that good influence on the child's life. So where de facto parental responsibility, as we have put it, but of course the court may decide not parental responsibility was in place, but that family life was in existence, we say that the making of a parental responsibility at an early stage, even if it is acknowledged that it's to be reviewed at a later stage once all of the welfare evidence is in, is a protective position and a position that preserves things for the child. If I may move on to my final point,
thank you. Yes.
my lords and my lady. Nobody in this case has suggested, and rightly so, I would propose that Baroness Hale in 2006 was wrong in Re G when she described CW, who was a female parent who was not gestational and not genetic, as a child's parent, as social and psychological parent. And it has been explicitly recognised on behalf of the Secretary of State for the Ministry of Justice that the contribution that non-genetic parents can have in children's lives deserves recognition and protection. And my lord, whereas the arguments before the court have dealt with what it means to be a legal father for the purpose of acquiring parental responsibility under Sections 2 and Section 4, in my submission it bears repeating that this does not narrow the way in which the court, social workers and CAFCAS officers can think about the reality of welfare for the child and can include, when they're thinking about parental relationships in the child's world and what needs to be protected for the child, who has been safeguarding the child's welfare, to whom the child is attached, and who has had that social and psychological parentage.
Yeah, and you make that observation not because you're saying that Baroness Hale was saying as a matter of law the psychological parent is a parent, but as a matter of the approach in welfare, that individual should be given a proper place in the evaluation of welfare,
Yes.
irrespective of whether they're the genetic person, because they are a very significant part of the child's life.
My lord, yes. And once we step out of the provisions of section 2 and 4 into sections 12 and into sections 8 in the welfare jurisdiction, the court is
So
not constrained.
the individual who perhaps has acted as the father of the child in ignorance of the true position for 10 or 15 years, and then the child is suddenly removed from that person's care. From the child's point of view, that person is dad.
Yes, yes. And
From the man's point of view, that child is his child, and so that the strength of the psychological social parent, whatever label you put on it, is of a high importance
yes,
to the child.
yes.
Yeah, and that's the point you're making.
That is
Yeah,
precisely the point I'm making, my lord. If I may please turn my back,
Thank you.
unless there's anything else.
No.
Thank you.
Thank you, Ms. Briggs. Miss Markham.
Thank you, my lord, my lady. I'm just going to take you very briefly to the fact-finding judgment and then just quickly look at
No,
where we
that
say
came on a link
it was.
with the email, which I didn't open because
No.
I've had meetings.
And perhaps, my lord, my lady, you don't necessarily need to look at it now
Right.
and could note down the paragraph. So paragraph 40, the learned judge directed herself, we say correctly, to the burden of proof within Re B. And I am not going to steal my learned friend Mr. Bagchi Casey's proverbial thunder on addressing you on the application of Re B to the facts of this case, because
Right.
he's going to deal with that. But that is where the learned judge dealt with it in the fact finding.
Right.
And then at paragraph 105,
So you're saying she was right.
there she was right.
Yes.
And there is a consequence to that that my learned friend is going to address you on in relation to where that
So-
takes us.
Sorry, I'm afraid I'm being curious as to just to make sure I've got my head round. So
Yes.
this was an email that came urgent.
When was it sent?
That was the live link. No, it's called it came to the court at 5:05 yesterday afternoon. It's called urgent re M re J re P. And it came from the listing office this morning at 8:52, and then my clerk forwarded it on to me. Right, here we are. So paragraph 40,
Paragraph 40.
wonders of technology. So the burden of proving an allegation is on the party who makes it. The standard proof about the problem. The court can only make a finding, only find an allegation proved it's in what level. Right. So yeah, obviously, yeah.
I got that right.
And my learned friend is going to develop that further, so I am going to restrain myself from so further commenting. But then at paragraph 105, just because, my lord and my lady, we didn't have this judgment before you yesterday, because it links in then to the paragraph 116, 117 and 130 we were looking at yesterday. Her Honour said, it follows that with real regret, I am unable to determine on the facts currently ascertainable which of F2 and F1 is A's biological father.
Yeah.
So that is where she made the original finding.
Yes.
We then say that the learned judge, was wrong at paragraph 10 of her order.
So that's in the bundle.
That is in the welfare bundle. I'm so sorry to be taking you through these, but I just thought it was right to go through finally what we're saying. Why?
This is the P. Ralph.
Page.
It's C588. It is at C5. electronic bundle 88. An application was
Oh,
made.
sorry, 88.
88 C5.
Same thing, that's in the main bundle, in the core bundle.
Sorry, yes, I was just using the welfare bundle.
No,
I
no, it's fine,
apologise.
just
Alright,
wanted to
no.
make sure we're not talking two different.
No, there is only one order. Yes,
So what paragraph?
10.
Okay. The application is made by the applicant. Removed from the birth certificate. Any parental responsibility are refused. Okay.
So we say the learned judge was wrong to conflate the two issues, which is the removal of the name of the birth certificate and recognition that she had been unable to find on the balance of probabilities that F1 was the genetic father, and therefore his name, his parental responsibility should be removed. He never had it pursuant to Section 4.
Right.
So that's where that part of the
Those
order
were
is in.
applications that had been made,
Yes,
and she refused them
she did.
because she had no power to grant them. So what's wrong with her refusing to grant?
Well, because she doesn't make it plain anywhere that F1 does not have parental responsibility arising from the finding that she could not say he was the genetic father of the child.
So,
And one
Judge-
reads the entirety of the order. There is the avoidance of doubt. He has it for the other child. There's no issue with that. That's paragraph 9. But if this order goes to school and to GP, the inference then would be, understandably taken, that because F1's name is on the birth certificate, he has parental responsibility. But we say because the court could not, on the balance of probabilities, identify F1 as the genetic father, he can't have parental responsibility.
Well,
under
the way
Section 4.
as I understand it, it's left by the judge is that she didn't change the position with regard to the birth certificate, and so whether or not he actually has parental responsibility turns on whether he actually is the father, and the judge couldn't determine that. So he may have presents an unsatisfactory position.
Well-
So what do you say the judge should have done?
We should have said for the avoidance of doubt, F1 does not hold parental responsibility.
So I think I suggested that yesterday.
Yes.
That not using Latin de bene esse,
Yeah.
the judge should have said there's a 50% chance that he is the father and he has parental responsibility because he's on the birth certificate under Section 4. In order to clear the decks,
Yes.
I'm going to make an order under Section 4(2)(a) discharging
Yes.
any parental responsibility he may have, and I'm now looking for the future and deciding whether he, and for that matter F2, should have parental responsibility through whatever orders I
Yes.
make for the child's welfare.
And we know
On
that
that, yeah.
the learned judge at that point in time was unclear.
And I think she didn't. I went back to the judgment overnight, and she didn't go there.
No, she didn't go there. No. And so I just wanted to confirm that is the part of the order we were looking at.
So,
and
and in terms of what the judge did do, perhaps we ought to go to the end of her judgment and see where it says it. Of course, I now can't find it.
the welfare judgment, my lord.
No, the parental responsibility judgment. So that's P, and so it starts at 224, but it's around 240, I think. So it's starts at paragraph 128, and so that's I think on 241. And we'll have that. So let's just take this a bit carefully. 128, mother has parental responsibility. 129, father, F2 currently doesn't have parental responsibility. If he does have, the court can confer, if he is the father, then the court can confer it. Then she goes on, F1 has parental responsibility for B, whether or not he has it for A depends on the answer to the question of whether
Yes.
or not he's the father. Okay. Then 131, rather than embark on a legal analysis, which may in any event be unravelled later by the Court of Appeal, I intend to deal with the issues of parental responsibility for both putative fathers by defining through a framework of specific issue and prohibited steps orders the scope of each party's decision making. And then she 132 sets out
Yes.
a list of ground rules, and then that's it. So what do you say we got to the point where you're saying what she should have done is clear the decks,
Yes.
and with avoidance of doubt, if he's got it, I stop it. What should she have done for parental responsibility
She
for the
should
two
have
men?
considered Section 12 orders of
Yeah.
non-parents
Yeah.
and whether or not those were orders that she should have and ought to have considered making,
Yes.
particularly given all of the different relationships each
Yes.
of the fathers had. Not least, an example, the point just made by my learned friend, Miss Briggs King's counsel, the psychological relationship
Yes.
between my client and the older child.
Yes.
But she didn't do that. And we say she was wrong not to have done that.
Yes.
And also, by leaving it in the way she has, with the order that she has made being disclosed to GP and school, there is an illusion that's existing
Yeah.
that F1 still has parental responsibility
Yeah.
when he may not have, and we say should not have,
Yeah.
at this point in time. And in fact, the only person that should have it is the mother.
Yeah.
And there are a whole cohort of difficult issues now that
Yes.
arise, not least an example would be if there is a further investigation into the welfare of the older child, social services or police involved, then my client has no status and no locus in relation to that. He can't
Yes.
ask what's happening.
Yeah.
He can't put himself forward for information. So
There's
those are the
there's a
difficulties
range
that
of
arise.
points. So if you're right about this, and we agree with you, then this needs to be considered at first instance again. So and again, obviously, having discussed it, we've picked up that the case is going to come back to the lower court anyway.
There have been some recent issues.
We're not going to be able to circulate our draft judgments, I'd have thought, before Christmas. It would be helpful if we were going to say that the first instance court needs to grapple with these PR issues afresh. It would be helpful if they're all done at the same time as any other matters are coming back. Do you know when they are likely to come back before the lower court? And if we can indicate our decision on this particular point,
No,
would that be helpful?
there is no current application afoot, and Ms McKenna and I and others may need to discuss as to whether or not there will be.
Right.
I'm talking
Okay.
in code for.
No, well,
for
don't
good reasons.
don't say any more. So so there's no need for us to take a different course other than
No.
get our judgments. I'm sure will be ready by the beginning of next term. So,
But my lord, my lady, if anything changes, we will alert
yes,
you
and
to
so we
that.
would be prepared to indicate
Yes.
our decision about the PR in your case and whether it needs to go back to first instance if that's needed, because it's clearly unhelpful for that to pop up after you've all been back for some other reason closely associated with it.
Absolutely.
Good.
Thank you. So I
With
leave
that,
my response to that point, and I align myself with the submissions that are about to be made in relation to the REB and the balance
Yeah.
probabilities.
Sorry, I haven't made a note of any of that last bit.
Thanks, Daisy.
So that's those are your submissions.
My lord, my lady, I'm reminded that Mr Justice Paul stayed paragraphs of the order, and we anticipate that those will continue to be stayed pending the judgment of this court.
Which paragraphs did he stay?
It is paragraph 6 and 11.
6 is the three of them have permission in principle to take the child out of the jurisdiction, so that's stayed.
Yes, and the prohibited steps order not to remove from the care of the mother. That's paragraph 11.
All previous Section 8 orders are discharged, including the prohibited steps order preventing him, F1, from removing the child from the care. So that's stayed.
That stayed as well.
So the effect is all previous Section 8 orders remain in place. Yeah. So, Ms McKenna, there's no, looking at you, there's no problem in that stay remaining while we consider our judgments. Is it you, Miss McKenna? I'm not
Sorry, I'm
No,
so
I
sorry.
think
Manon.
Mr. Bagshi has been headlined
Yes.
by Miss Markham.
Aren't you in the case?
I am in the case.
So do
but
you have
I'm
any
not an
problem about, do you
appellant.
have any problem about the stay continuing?
Oh, I beg your pardon.
No.
That was.
No, it's all right.
Right exhibition.
Probably more interesting than what I was saying.
The stays, I invite the court very clearly to leave those in place.
Yes, I thought you would. And I'm assuming every other party's comfortable.
We were just discussing which
Good.
numbers they were and checking the.
Very good, thank you.
And I was right, my lord, my lady, when I made it plain, it's in relation to the prohibited steps order only in the judgment of Mr. Justice Poole. I wouldn't want the court to think it is the entirety of that paragraph that was stayed. That's why I said in relation to prohibited steps order.
Yep, thank you. Yes, yes, Mr. Baggs.
Just two or three relatively short points, if I may. I don't know whether the court would be assisted by me addressing just one of the fairly narrow points made by my learned friend Miss Baisley, King's Counsel, yesterday, as to the for all time nature of declarations of non-parentage, which I think was being advanced as a reason not to go there, because the facts on the ground may change and the family would be stuck with the declaration for all time, because as a matter of law, we don't accept that a declaration of non-parentage would maintain beyond any changing of the facts on the ground and any subsequent application, because that would seem not to accord with.
I think Ms. Baisley's submission was based on the understanding that it's the birth certificate. Once you've amended and reordered the birth certificate, then that stands for all time.
But we don't accept that, and I think my learned friend Miss Clement KC interposed a short submission to address the linkage between section 55A and the obligation on the part of the registrar to consider re-registration under section 14A. And that would take place on the first declaration, and if a subsequent amending declaration was made, then that would be triggered pursuant to the terms of the statute in any event.
Yes.
And obviously that makes sense, because if the facts on the ground change, then it would be odd if there couldn't be a formal response.
It would be, I mean, this is a very unusual case, and it would be highly unusual because the circumstances wouldn't happen for the registrar to be approached twice to re-amend a certificate. But certainly my understanding would be that you can never say never, and if there was a further declaration, then the registrar could be approached again, and obviously up to the registrar what they do.
That would be, I mean, I can develop.
It's not looking at Ms. Clemens, it's not ruled out.
My lord, there's nothing in section 14A that says this can only happen once.
No.
I'd imagine in most cases it only does happen
No,
once.
yes, because
but we can all think of scenarios that we thought were certain, but it
Yes.
subsequently turns out we're not.
No. Thank you.
I shan't develop that any further, because I agree with
we've
that
clarified
analysis.
that, yes. Thank you.
The second point was just a bullet point, and this is now in the context of the debate that we undertook yesterday in relation to the impact of the reasoning propounded by Lord Justice Peter Jackson in paragraphs 38, 39 and 41 of PQ&F, which and I'm not going to repeat those submissions because I hope, whether or not they are accepted by the court, I hope they were, the logical reason and analysis was clear. But the reason why it's so important in this case, and just a bullet point, the consequences if F1 is not removed from the birth certificate, or his PR is not removed.
Either or both.
Well, both.
So if he's not removed from the birth certificate.
His PR maintains until a subsequent application is made under the Children Act to disturb that position. Yes. So it's, my lady's right, of course. Yes, it's both. There's no parity between the twins, which we submit there should be. The public record is not accurate, and this court would be seen to be sanctioning the maintenance of that position. It's contrary to the overarching principle, which we've spent some time on, that the formal documents of identity must be accurate. It's potentially confusing for the child as the child gets older and becomes aware of what has happened. And we still have to address the question of this hovering parental responsibility, but that may be addressed.
So just pick you up on confusing for the child.
Yes.
It's not going to be any more or less confusing for the child, because the true position, whether or not in future genetic parentage is established by evidence, the true position the child will inevitably come to learn at some stage is that there was a period when it wasn't known whose father was.
I accept that, but on the ground, it may depend how each individual candidate frames and represents the outcome of the court process.
As I understand it, each of them is currently telling the child, it's me.
Yes. It seems to be the position.
Seems to me that child's probably pretty confused already.
Yes.
And shown the birth certificate.
Quite so. And so finally, can I just come back to the what we say are the implications of the analysis of Lord Justice Peter Jackson on the facts of this case? And it really comes back to the fundamental point in relation to the application of the binary system of proof. Because we are used within the family justice system, I suppose, to understanding the distinction between absolute truth and a legal truth.
It's not confined to the family division.
Of course. So, for example, up and down the country every day, fact-finding hearings are taking place in relation to allegations of inflicted injury in relation to children. And we know from high authority that one possible outcome is the court is simply unable to say that the evidence is of sufficient quality to discharge the burden of proof, and that the cause of the injury was unknown. And that is a finding which is sometimes made because the burden of proof is not discharged by the applicant party. And the alleged perpetrator in those circumstances, as a matter of law, is entitled to be treated as not having inflicted the injuries. Not that it's unknown, not that there's a shadow of suspicion cast over them by reason of the court being unable to say, but because the binary system requires that person to be treated as, inverted commas, innocent, and that is the legal truth in that moment. Now, if the facts change and it's subsequently CCTV evidence comes forward and establishes that in fact it was an inflicted injury by that person, then the legal truth will then align with the absolute truth. But there is that distinction which the system recognises. And we say by parity of reasoning here, if the binary system is approached in the same way, on the basis that the starting point must be the common law, then neither F1 or F2, and I can see how the introduction of F2 into this, as discussed yesterday, might confuse the analysis. Let's just say F1, because that's the analysis which actually has impact on the formal documentation in this case. F1 cannot establish to the tune of 51% that he is the father. And so a proper application of the binary principle through the prism of the common law means that he cannot establish it, and therefore he is not. And the formal reflection of that state of affairs bites in our submission on 55A1, because he cannot establish that he is the father. And the proposition, as explained by Lord Justice Peter Jackson in between paragraphs 38 and 41 of PQNF, it is the truth of the declaration. And the truth of the declaration sought is that he is not the father. And that position has already been arrived at before you come to an analysis under section 55A1, because that's where the common law leaves you. So it's a two-stage analysis: the common law position, and then you apply the statute. And you apply within the common law position, you certainly have the binary approach.
Look at section 58.
Yes.
1. That's the Family Law Act. So that's at page 230 of the Electronic Authorities Bundle.
My lord, yes.
So if you're going under section 58, where on an application for a declaration under this part, the truth of the proposition, so the truth of the proposition is that he is not the father, to be declared, is proved to the satisfaction of the court shall make that declaration, unless it's contrary to public policy. Well, the court, in saying it's not proved that he's the father, is not finding proved that he's not the father. So the court couldn't make a declaration under section 58, on my reading of it, saying he is not the father.
But that misses out.
It has to be that there's a difference between saying it's not proved, and so on the binary approach, he's not the father. This requires the court only to make a direct declaration when it's satisfied that it is proved that he's not the father. Do you see the difference?
But the way in which Lord Justice Peter Jackson squared the circle on different facts, I accept, because there was the statutory alternative in PQNet. But the way he squared the circle in those paragraphs was to track back to the common law starting point and to apply the binary principle in relation to that to give you the answer, and then to use the answer produced by that exercise within the analysis under section 58(1). And if that's a logical approach, which we submitted that it is, then it does enable the court to reflect the legal reality, which is that neither are the father. That may not be.
Child has no fathers.
Yes.
There's no father. And as I said yesterday, that doesn't do a lot for your core submission of truth and identity.
And I think these are very unusual submissions
yes.
for a guardian to be making.
Yes.
Seems to me. You know, the guardian, the ALC's submission is very clear. What children want is the truth. And a declaration that someone who may well be the father is not the father seems to me to be a fiction, go against the truth.
But the ultimate outcome for this child in this case
the reason for making this
is to achieve a degree of parity between the two candidates.
No. And this is a contrivance in order to achieve the goal of taking the F1's name off the birth certificate. And I think that's a disproportionate method to achieve that, which may well be a desirable outcome. And you've got to make the submission in that way and understand why you're doing it, because the advice through the submissions of the Registrar General is that unless it's in clear terms that he's not the father, they're not going to amend the certificate, and that's to be accepted.
And Mr. Bouchy, parity is about parity for the child, and parity can be achieved through welfare analysis by the court dealing with it by way of parental responsibility orders for either or both of them, by lived with orders, by time spent with orders. So far as this child is concerned, it's parity of opportunity for the court to be able to make the right welfare decisions for that child, and the ability to utilise whatever orders under the Children Act are necessary in order to achieve that.
Of course, I accept that, but there's a difference between parity on the ground by the making of welfare provision and formal legal, formally recognised documentary parity, which will not be achieved for this child in this case. And it rather depends on what priority the system gives to all of the learning that we went through yesterday in relation to the documents being accurate.
Yes.
I don't think it should be determinative, but do we actually know who made an application and what the declaration that was sought was?
F2 made the application, I
Yes.
think.
F2 made the application that F1 was not the father.
Yes.
Okay.
I couldn't prove.
That was the conclusion of the learned judge. And the alternative that we put forward at the conclusion of the evidence was that there should be an equal approach in relation to F1 and F2, hence paragraphs 1, 2 and 3. I'm just going to turn my back, if I may. Oh, yes, of course. What we had done overnight was to just to reflect upon some of the debate yesterday in relation to the framing of the declaration.
Yes.
And in fact, we typed it out. We can hand it in. I'll read it out because it's very short. It provides as follows. Having applied the provisions of sections 58A1 and 55A1 and 58(1) of the Family Law Act 1986, comma, it is declared that F1 is not the father of A. And so what that seeks to do, again, in a way to send a message to the registrar, is to indicate that the court has applied the framework of the Act, including has assessed the truth of the proposition to be declared under section 58(1) before making the declaration.
So your submission, just so I'm clear how that fits together with your declaration, is that we should read down section 58(1) from the wording of the statute in this statute to your binary submission.
Yes.
It would require reading down because
Well,
it doesn't tie in with the wording.
That rather depends on how this court takes the analysis of Lord Justice Peter Jackson in the PQ&F case in that way. I think that's at paragraph 38 to 41 at bundle 4, 1453.
I'm so busy with the page number. What paragraph number?
It's 38 to 41.
Sorry, could you give me the paper number again?
It's page 1453, bundle 4.
So can we just read those 3 paragraphs, 4 paragraphs?
How far do you want us to go?
Just to 41, but the passage, in fact, the sentence I place particular emphasis on is the last sentence of paragraph 39, which starts, it does not import a burden of factual proof, that one. And then paragraph 31.
And I don't know what that means, because if you're determining paternity, you are determining paternity and you use the burden of proof and the standard of proof.
But my submission
the
is,
fact.
what the learned judge was reflecting there was that section 55A is a facilitating measure to reflect an underlying state of affairs, because we draw that from paragraph 41. The underlying state of affairs.
And it is not, with respect, entirely clear, but what the paragraph 39 is about section 58(1), which is the subsection we went to a short time ago,
Yes.
which says that if the court's satisfied it's proved, it must make a declaration. And I wonder whether Lord Justice Peter Jackson is saying that structure in that subsection which says if you've got that fact, you must make a declaration, doesn't import a burden of factual proof that's different to the ordinary burden into section 55A. It simply mandates the consequences of the court reaching its conclusion. So I don't. Is your submission that Lord Justice Peter Jackson was saying a different burden of proof applies to issues of paternity,
I think
other than the balance of probability or the burden being on the he, as it is in this case, he who asserts?
I think what I'm really saying is that what he was saying is a two-stage process, because we derived that from reading on to paragraph 41. Yeah. And you look at the common law position, and you apply the conventional approach in relation to that, and you get an answer, and you apply that answer to the facilitating statute, which is section 55A, in order to yield a result.
This part of the 1986 Act is quite tightly structured. It's plain that it's not a welfare decision. It's plain that if the facts are established, the court has a very limited discretion as to whether to make a declaration. And my reading of this is that the court can use welfare to decide whether it allows the application to proceed. But once it's proceeded, subject to a public policy caveat at the end, if it's proved, it's got to make the declaration, because this is about identity and status. And if it's proved, it's got to make the declaration. So that's what this is about, I would venture.
Yes, well, I'm not agreeing with that, but I think what I'm really saying is that the analysis which I've identified, maybe that the court doesn't read it in the same way.
I'm just trying to understand. Well, what is it that help me? What is it you're saying that these paragraphs mean that we can do on the facts of this case in P?
It means you can take the learned judge's first instance findings of fact.
Can't say one or the other.
To apply the binary system to that in relation to the question as to whether or not the question either of the potential candidates can establish that they are the father, and the answer is no, and that is the state of affairs at common law, and to apply that conclusion to the question as to whether or not it has been established on the facts of this case that F1 is not the father, because as a matter of law, by the time you ask that question, it has been established that he is not the legal father of this child, because the legal position after the common law analysis is that he's not. And I drew the distinction a few minutes ago between, I suppose, the legal truth and the truth on the ground.
Thank you.
Unless I can assist any further.
No, thank you very much, Mr. Bagchi.
Yes. I rise only on the point of law that I say the submissions just made by Mr. Bakshi are incorrect. We submit that the combined effect of section 58, in particular section 58.2 and the authorities, is that a declaration once made is binding for all time. And that was the point of my submission, that if as a result of a declaration that F1 is not the father, he was removed from the birth certificate, there couldn't be a further declaration that could put him back on. And may I invite you to look at 58.2, you may be very familiar with it. It simply says a declaration made under this part shall be binding on Her Majesty and all other persons. We deal with this in our skeleton argument starting at page 11.
Can you give us the page number for section 50?
Yes, I'm just going to...
230.
Thank you.
230, thank you.
Right.
And then if we look, please, again at the Secretary of State for Work and Pensions and Jones, which is in the authorities bundle at page 2498.
Yes.
And I direct your attention, please, to page 2498, paragraph 17. In that case also, the court was considering section 55A and section 58(2) and records the subsection, any declaration under this part is binding on Her Majesty and all other persons. Consequently, if one looks just below that, the magistrates by their decision have, according to Mr. Forsyth, and it appears to be so, made it impossible for the child ever to seek a declaration as to who is his true biological father, because the magistrates have found that Mr. Jones is not so to be seen. That declaration is binding on all parties. And then goes on to say in the next paragraph the reasons why that would be unjust.
Yeah.
And we refer in our skeleton argument, paragraphs 12 and 13, to other authorities on the same point, including Court of Appeal Authority.
Sorry, what paragraph of your skeleton argument?
12 and 13, my lady. And indeed 14. So in our submission, that creates a real difficulty and is another reason why, even if declarations were possible, they shouldn't be made on the current information. And for completeness, we submit that the declaration now sought is not permissible. Can I just, and I know I don't have a right to reply on this, say that in our submission the judge's order made it perfectly clear how she's dealing with parental responsibility. She records that, for the avoidance of doubt, F1 has parental responsibility for the child B, and she deals with the rights and duties of the parents as we've already submitted by a series of orders, a framework of orders that puts both putative fathers in the same position. And she had a discretion to make a parental responsibility order for one of the putative fathers under section 12, but she didn't. And we say that
in the judgment, does she acknowledge that she'd got a discretion under section 12 and that she considered making an order under section 12? And I don't have every sympathy for the judge. You come in on a Monday morning and you get this. Another aspect was raised, I think, by Miss Markham, that if there were care proceedings, F2 wouldn't be a person because he hasn't got parental responsibility who would be on the radar legally for the local authority. There are other aspects which, again, the judge doesn't seem to have.
F1 is in the same position. So
no, FF1 can come along and say, I might have parental responsibility.
Well, if this court finds he doesn't, by reason of being on the birth certificate and not having established that he's genetic father, he's in exactly
but the way the judge left it, he's on the birth certificate.
Yes. I don't know whether that gives him parental responsibility, is the way she left it.
So your submission is there was nothing.
There's nothing wrong with it.
Nothing wrong with the way the judge dealt with parental responsibility.
And in terms of the order, which can be produced to various people, the order itself doesn't declare that F1 has parental responsibility.
No.
So two fathers are exactly, putative fathers are in exactly the same position. There's no unfairness there.
Good. Thank you. Have we exhausted you? No, Miss Briggs.
I rise only as a matter of courtesy. Have no fear.
Very good. Anything else? No. No, well, this is a case that you'll all remember. We will reserve our judgments. We're keenly aware that there are real human beings involved in this who are anxious about the outcome of the case. It's important to them, it's important to the children. And we've conducted this hearing very much as lawyers conversing with each other, but I haven't lost sight of the fact that the parents and the children will be impacted by these decisions. We'll reserve our judgments. We'll, as I've indicated, probably not circulate any drafts until after the Christmas break. And then when we do, that'll be to encourage you to spot the inevitable typographical errors, but not to re-argue. If there's a need for us to deal with it any more quickly than that, then please contact our clerks. Mr. Gratian, you're going to have consider if there's any further suggestions of guidance that might be sent in. So please, can you do that within the next fortnight?
Yes, of course.
Well, I have thought of one more. I don't know whether Milord wants me to put in an email, which I'm happy to do, but it's very quick. I can deal with it very quickly if Milord wishes me to.
Yeah, sort of one more.
One more in respect of the parental responsibility point, not
Right,
in relation.
sorry.
Can I just deal with it very quickly? I'm sorry, I only thought about it when I was sitting down. It's simply this.
Often the best points are made sitting down.
If one Googles parental responsibility, the first thing that comes up is the gov.uk website. And we have
gov.uk.
website, yes. And we, in our skeleton argument at 151 paragraph 9, have set out the explanation it gives there about parental responsibility. It may be that one helpful suggestion might be for an explanatory text to be added to that website.
Okay.
Because that's a source of primary information for members of the public, I'd suggest. Just a suggestion, it may not find favour with the court.
Yep, well, that's helpful. Good. Thank you very much. We'll rise.
It's off.